Constitution of the United States of America, Fourth Amendment reads, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath and affirmation, and particularly describing the place to be searched, the persons and things to be seized.
What's up, everybody? And today I wanted to get right into it and thank Joseph and Cecily. They were one of the donors that did not like the sponsors being
all in the video, all on the record.
So they did something about it, and I appreciate it. Keep donating. But today I'm going to talk about a MAP hearing, the importance of a MAP hearing. Now, MAP hearing comes from MAP v. Ohio 367 U.S. 643 1961, and it reads, evidence obtained in the violation of the Fourth Amendment, which protects against unreasonable searches and seizures, may not be used in state criminal prosecutions in state courts, as well as previously been the law as in federal criminal law prosecutions in federal courts. So again, at the beginning of this video, you saw the reading of the Fourth Amendment of the United States Constitution. You also heard me in the last video talk about the MAP hearing for suppressing evidence and what made it eligible for suppression, because the reinforcement of the supreme law of the land, as in Howlett v. Rose, because federal statutes and Supreme Court cases are to be applied in state court cases. And I also put that up with another court case, again, in the last video. And I'm going to continue that with Stanford v. Texas, 379 U.S. 476 1965. The protections of the Fourth Amendment are by the 14th Amendment guaranteed against invasion by the states, and the states may not constitutionally issue general warrants which do not describe with particularity the things to be seized, a requirement of the most scrupulous exactitude where the seizure also impinges on First Amendment freedoms. Because you remember yesterday I talked about seizing of documents. It has to have something to do with the crime. A lot of times you see them grab stuff like computers, they grab iPads, they go into phones, and they do all this and nobody suppresses them. But when they are challenged, generally those things are now taken out of evidence because those things have nothing to do with the crime in which they were charged. Keep that in mind. The warrant must contain the exacts of who they are arresting. They must contain what they are looking for, and it must contain the crime they are investigating. And later I'm going to go into something that's called fruit of the poisonous tree doctrine, because it also deals with MAP hearings, and it also deals with Fourth Amendment search and seizures. You heard me say once before, a legal act cannot follow an illegal act. And just like that with suppression, if you find something that even pertains to a crime, but it's after you've done something that's outside the scope of the warrant, it also is subject to suppression according to the fruit of the poisonous tree doctrine. Because an illegal act cannot have a legal act follow it and be justified. One more time, an illegal act cannot have a legal act follow it and it still be justified. Hence, anytime your locomotion is stopped, there must be probable cause. Again, not me, that's Delaware v. Prowse. But again, we'll get into those things deeper. But this is what I'm talking about now, because even those acts fall under MAP hearings for evidence for suppression, because there also must be an oath from someone that is a first-hand witness. You remember I talked about standing. We also talked about having a complaining witness. but someone must be a first-hand witness to affirm for the search warrant.
Do not try and bend the spoon. That's impossible. Instead, only try to realize the truth.
What truth?
There is no spoon.
There is no spoon?
Then you'll see that it is not the spoon that bends, it is only yourself.